Welcome to the Luxembourg Funcast. Today we're taking a deep dive into Luxembourg legal opinions. Those crucial avis juridiques you hear about. They really underpin so many financing and banking deals here in Luxembourg, don't they? Kind of grease the wheels of the whole financial system.
They absolutely do. And it's key to understand what a Luxembourg legal opinion is in this finance context. It's basically a formal written statement, comes from a lawyer or usually a law firm.
Right.
And it gives their legal conclusions on, specific bits of a transaction or maybe the legal status of a company involved, all under Luxembourg law, of course.
So it's an expert assessment, but not like a guarantee.
Exactly. Not a guarantee, not an insurance policy. It's based on a very clearly defined scope. It has some parallels, conceptually at least, with the avis juridiques the Conseil d'État gives on draft laws, providing legal clarity.
Okay.
But here it's for financial transactions. And Luxembourg legal opinion in finance, that's a pretty established term now.
So fundamentally, what are they trying to achieve? What's the purpose for the people involved in a deal?
Well, their core purposes are quite broad, actually. First off, they give assurance.
Assurance?
Yeah, assurance to the parties. Think lenders, investors, people like that. Assurance on the really critical legal points they need to feel comfortable about before, committing serious capital.
Okay, like what specifically?
Things like confirming that the Luxembourg companies involved are properly set up, that they actually exist legally and have the power to do the deal.
Right.
Verifying who has the authority to sign the documents, that's crucial.
Yeah.
And, of course, confirming that the main promises in the contracts, the obligations, are actually legally solid and enforceable under Luxembourg law.
So it's really about building a solid legal base for the transaction.
Exactly that, laying the groundwork. They also confirm if any security, like a pledge over shares or accounts, is effective, making sure it works legally.
And they can flag risks, too.
Yes, definitely. They can highlight potential legal pitfalls that might need fixing before the deal closes. And there's a regulatory angle, too. The CSSF, Luxembourg's financial regulator.
Our financial watchdog.
Right. They can actually ask for legal opinions, for example, to check if a securitization deal meets all the rules.
Interesting.
Lenders also look to them for comfort. Comfort that the security you're getting is properly established, and also on something called COME.
COME.
Center of Main Interests. It's basically the company's main hub for insolvency purposes, important stuff if things go wrong.
I see.
And in the repo market repurchase agreements, updated opinions are often needed for regulatory reasons. They help with closeout netting calculations and can even reduce the capital banks need to hold.
Okay, let's circle back to something you mentioned earlier. You called this a delicate transplant, a common law idea in Luxembourg's civil law system. Can you unpack that a bit?
Yeah, it's a really interesting point. Using these super detailed, bespoke legal opinions for every finance deal, that's much more typical of common law places like the UK or the US.
Where precedent is king.
Exactly. Where case law and specific analysis drive things. Luxembourg, though, is a civil law jurisdiction. Traditionally, you look more to the comprehensive written laws, the codes.
So asking for these specific opinions is different.
It's a bit of an import, yeah. In pure civil law theory, the code is the primary source of legal standing. So Luxembourg lawyers have become really skilled at bridging this conceptual gap, especially for international clients who expect these opinions.
And those clients need to understand the Luxembourg context, too.
Absolutely. They need to grasp how these opinions work here, what they cover, and just as crucially, what they don't cover. Misunderstandings can happen if that scope isn't mutually clear.
Which puts a premium on skilled local counsel.
Definitely. You need lawyers who can navigate both traditions effectively.
Got it. So who are the players in this ecosystem then? Who's writing these opinions and who's relying on them?
Okay, so the issuers, the ones writing the opinions for these big finance deals, are overwhelmingly independent, regulated Luxembourg law firms. Names you'd recognize are active here.
Not the company's own lawyers.
Generally not for third-party reliance, no. While in-house legal teams are vital internally, external parties like lenders need that objective third-party view. There's a perception issue around independence. Plus, external firms carry professional indemnity insurance that covers third-party reliance.
Oh, the insurance aspect. Makes sense.
And it also matters whose lawyer is giving the opinion. Is it the borrower's counsel, the lenders, or maybe they split the coverage? That happens too.
And on the receiving end, Who needs these documents?
Oh, a whole range of people. Lenders, obviously. They need to know the loan agreement and the security are enforceable.
Top priority for them.
Absolutely. Then you have investors, underwriters, especially in capital markets, deals like bond issues. They rely on opinions about the issuer's legal status.
Right.
Arrangers, the ones structuring the deals, security agents or trustees holding collateral, they all need them. And like we said, regulators like the CSSF in certain cases, like securitizations or for those repo netting opinions.
So it's not just a private deal thing. Regulators care too.
Exactly. That dual audience, private players and public supervisors, really elevates these opinions. They're not just a formality, they're fundamental for market confidence and regulatory compliance. It shapes how detailed and precise they need to be.
Okay, so where do we actually see these opinions being used? What kinds of deals?
They pop up almost everywhere in finance, really. Standard corporate lending, whether it's secured or unsecured, syndicated loans where multiple banks team up,
Right.
financing for big acquisitions, real estate deals, project finance, asset finance, think planes, ships.
Okay.
Capital markets deals are a big one. Bond issues, note programs, fund financing to subscription lines, NAV facilities where opinions cover security over things like capital calls or fund assets.
That's a core Luxembourg area.
Yeah, definitely. Securitizations, obviously, where opinions cover the structure, the true sale aspects, and just general lending and finance deals of all shapes and sizes. They're pretty ubiquitous.
And given Luxembourg's role as this international hub, they must be critical in cross-border transactions, right?
Yeah.
Where you've got multiple countries involved.
Oh, absolutely essential. That's where they really shine. So many deals here involve parties or assets or laws from different jurisdictions.
It gets complicated fast.
It does. And a Luxembourg legal opinion provides that vital clarity and comfort to the foreign parties on the bits governed by Luxembourg law, international lenders, investors. They might not know Luxembourg law inside out. They rely on these opinions to confirm things like, is this Luxembourg company properly set up? Can it legally do this deal? Were the documents signed correctly? Is the security valid here?
Crucial questions.
Especially in the fund industry, which is massively international. Think about guidance from bodies like ESMA, opinions on fund structures, managers. They're indispensable for global players. Some guides are even written specifically to help foreign lawyers understand how Luxembourg opinions work.
So they act like a common language.
Exactly, a common language or bridge of trust. They cut through legal uncertainty and really help international capital flow smoothly into and through Luxembourg.
You mentioned some key laws earlier. Can you give us a quick rundown of the main Luxembourg statutes that form the basis for these opinions?
Sure. The absolute cornerstone is the Law of 10, August 1915, on commercial companies. That's the bedrock for everything about how companies are formed, how they operate, their powers, governance. It's what backs up opinions on due incorporation and corporate power.
Okay, the company's law. What else?
Then there's the Law of 5, August 2005, on financial collateral arrangements. Super important. It governs how you create, perfect, and enforce security over financial assets like shares or bank accounts, and also netting agreements. Vital for security opinions.
All right, the collateral law.
The Law of 5, April 1993, on the financial sector, the LSF. That's relevant when you're dealing with regulated entities like banks or investment firms. Covers their licenses, obligations, including professional secrecy rules. And you can't forget the Luxembourg Civil Code. That provides the general background rules for contracts, property law, enforceability.
The foundation.
Exactly. Plus, you have EU regulations that apply directly, things like DORA on digital resilience, CRR on bank capital, the recast insolvency regulation for cross-border insolvency issues, which impacts those POMA opinions.
And anything else specific?
Well, the Law of 10, November 2009 on payment services is key for payment institutions, especially with recent CSSF circulars linking it to DORA compliance. The main takeaway is these opinions aren't just pulled out of thin air. They are solidly grounded in these specific Luxembourg laws and regulations. That's where their legal rigor comes from.
So once a deal is moving, what's the very first step to actually get one of these opinions? Sounds like documentation is king.
Absolutely. Documentation is the factual bedrock. You can't have a reliable opinion without it. These opinions are tied directly to the facts laid out in the specific documents the lawyers have reviewed.
Accuracy is paramount then.
Accuracy, authenticity, completeness, all critical. The opinion itself will list exactly which documents were examined, defining that factual universe.
And who gathers all this? Is it the lawyers?
Mostly The company being opined on the borrower, the guarantor, whoever, they provide their corporate documents, certificates, etc. The transaction documents themselves, like the loan agreement, usually come from deal parties, like the lender or arranger.
Okay, can you give us a feel for what kind of documents a typical Luxembourg company needs to provide for, say, a standard financing? Sounds like a lot.
It is quite comprehensive. On the corporate side, you need their up-to-date constitutional documents, the coordinated articles of association, the statutes coordinate that shows their powers, how they're run.
Got it.
A fresh official excerpt from the Luxembourg Trade and Companies Register, the RCS, confirms they're registered, their status, the latest shareholder register.
Okay.
Critically, certified copies of resolutions from the board, managers, maybe shareholders, proving they actually approved the deal, authorized signing, agreed to perform the obligations, any relevant powers of attorney too.
Proof of authority.
Exactly. Then you get certificates from the company directors or managers, an incumbency certificate listing who can sign, a solvency certificate stating the company is solvent, and often a general certificate confirming things like no conflicts with other agreements, no hidden lawsuits, accuracy of information provided.
Wow.
And if it's a group structure with guarantees or security from multiple entities, you'll need a chart showing how they all link together.
That covers the company itself. What about the actual deal documents?
Right. Then the transaction documents. Both the agreed drafts and, crucially, the final signed versions. The main loan or credit agreement. All the Luxembourg law security documents, pledge agreements over shares, bank accounts, receivables, maybe assignment agreements.
The security package.
Yep. Any intercreditor agreement if there are multiple layers of debt, guarantee agreements, fee letters if they contain binding obligations. For capital markets deals, the prospectus or offering memorandum is key.
And searches.
Yes, searches are important, primarily in the RCS again, specifically checking for any signs of insolvency proceedings, bankruptcy, controlled management, that sort of thing. Sometimes searches in the beneficial owners register, the RBE, might be done as part of wider checks, though opinions don't usually cover RBE compliance unless specifically asked.
And anything else?
Could be. Depending on the deal, maybe specific licenses the company needs for its business. Copies of other major contracts if the opinion needs to state no conflict. Sometimes audited financials, though that's often more for the lender's credit check. It mirrors the kind of detailed info the CSSF might ask for when authorizing firms.
So once this mountain of paperwork arrives, how do the lawyers actually process it all?
It's a detailed due diligence exercise. They review everything carefully, verify information, cross-reference documents. They rely on the accuracy of what the client provides in those certificates, and on public records like the RCS, but only as of a specific date.
So the opinion rests on that review.
Completely. It's the direct result of that diligence, not some abstract legal thought experiment. Every statement in the opinion needs evidence from those documents and searches. That's why the quality and completeness of the documentation are so vital. It directly impacts whether counsel can opine and how reliable the opinion is. Gathering and reviewing it all. Foundational and definitely time-consuming.
Okay, let's dissect the opinion document itself. What's the typical structure, the anatomy, if you will?
Sure. They tend to follow a pretty standard format. You'll start with who it's addressed to, the lender's agent, bond purchasers, etc. The date is critical. It speaks only as of that date, and it will state clearly it's governed by Luxembourg law.
The basics up front.
Exactly. Then a really important section, scope of review or documents examined. This lists precisely every single document the lawyers looked at. That sets the factual boundaries.
Okay.
Next up, assumptions. This is where the lawyers state what they've assumed to be true without checking it themselves.
Like what?
Things like signatures being genuine, copies being true copies, the info and company certificates being accurate, non-Luxembourg parties being properly incorporated and having capacity, draft documents being signed without major changes, things like that. Also, assumptions about the deal's commercial purpose, no illegal activities.
So ground rules for the opinion.
Precisely. Then you get to the heart of it, the core opinion statements. These are the actual legal conclusions based on their review and understanding of the law. We can talk more about specific clauses.
We will. What comes after the core statements?
Qualifications and limitations, sometimes called caveats, hugely important. They define the opinion's limits, highlight general legal principles or specific circumstances that might affect the conclusions.
Like exceptions to the rule.
Sort of. Common ones relate to insolvency laws overriding agreements, general principles of public policy in Luxembourg, how courts might apply equitable principles, limits on certain remedies. They also typically exclude matters of pure fact and areas like tax, accounting, competition law, things outside the finance lawyer's usual scope. And crucially, they only cover Luxembourg law, not foreign law.
Right.
They might qualify opinions on security perfection if steps are needed elsewhere, or note limitations on enforcing penalty clauses.
And finally,
Reliance provisions specifies exactly who can rely on the opinion and only for the specific transaction it relates to. No circulating it or quoting it without permission.
so these assumptions and qualifications, they don't weaken the opinion.
Not intentionally. Their purpose is to clearly define the scope and the limits. It reflects the reality that a legal opinion is an assessment based on specific facts and laws at a specific moment. It manages the law firm's liability and gives clarity to the recipient about exactly what assurance they're getting. Understanding these is just as vital as reading the positive opinion statements. It provides assurance, yes, but not an absolute guarantee beyond its stated scope.
Okay, let's really dig into those core opinion clauses now.
Yeah.
What are the common ones we see and what are they actually confirming?
Right. So a very standard one is due incorporation. Confirms the company was properly formed and legally exists under Luxembourg law, based on the company's law, RCS excerpt, articles.
Basic but essential.
Absolutely. Then corporate power. This confirms the company has the legal capacity within its corporate objects or purpose to enter into the deal and perform its obligations. Again, comes from the articles, company's law.
Can it legally do this?
Exactly. Next, due authorization, execution, and delivery. This is the company took all the right internal steps, board meetings, resolutions to approve the deal, and that the documents were properly signed and delivered according to Luxembourg requirements. Relies heavily on those corporate resolutions.
Proof of internal sign-off.
Then a big one for lenders. Legal, valid, binding, and enforceable obligations. This states that the company's promises in the transaction documents are, under Luxembourg law, legally sound and can be enforced through the courts. Draws on the civil code, specific laws like the collateral law.
The enforceability opinion. Crucial.
Very. For secured deals, you'll get opinions on the validity and perfection of security interests under Luxembourg law. Confirms a valid security interest was created and necessary steps taken to make it effective against third parties. But remember, no single central register for all security types here.
Good point.
We often see recognition of choice of law. This confirms a Luxembourg court would likely uphold the party's choice of, say, English or New York law to govern the main contract based on EU rules like Rome Cers.
Okay.
Similarly, recognition of jurisdiction submission to foreign courts confirms if a Luxembourg court would recognize the party's agreement to use courts in another country based on rules like Brussels I recast.
Useful for international deals.
Very. Others include no violation of Luxembourg law or constitutional documents, the deal doesn't break general law or the company's own rules. No necessity for further filings or registrations in Luxembourg for validity. Again, bearing in mind, no central security register. An absence of insolvency proceedings opinion based on those RCS searches and company certificates. And an opinion on compromise, center of main interests, giving a reasoned view on whether the company's compromise is likely in Luxembourg for EU insolvency purposes.
The COMI point again.
Yes. And finally, netting opinions. Confirming that closeout netting provisions, especially under the collateral law, are valid and enforceable even in insolvency. Really important for managing risk and for regulatory capital calculations. So you see, each clause targets a specific legal risk, uses different evidence, different laws. It's a granular approach for a comprehensive check.
It sounds incredibly detailed. Is there usually negotiation around the exact wording of all these clauses? Seems like there could be.
Oh, absolutely. It's very rare for a legal opinion to be issued just like that without discussion. There's nearly always some back and forth.
Why is that?
It's a balancing act. The recipient, the lender, usually wants maximum comfort on the legal points. The law firm giving the opinion has a professional duty to only state what they can confidently support based on their work, and they need to manage their own liability.
So who gets involved in these negotiations?
Typically, it's the lawyers on both sides for the recipient and for the issuer to the opinion. Sometimes the business people get involved if there's a major commercial point tied to the wording, or if the lawyers reach a deadlock.
And when does this usually happen? Late in the game.
Often towards the end of the documentation phase, but ideally you start the conversation earlier. Discussing the expected scope early on helps flag any potential issues and avoids last-minute scrambles or delays to closing.
Makes sense. What do they actually negotiate?
The precise scope, what exactly is being opined on, the specific wording of the legal conclusions, and importantly, the assumptions and qualifications, are they reasonable, necessary, standard for this type of deal? There's often talk about market standard, but they can be a bit fluid and needs tailoring.
You mentioned split opinions earlier, too.
Yes, that's a common practice. The borrower's lawyers might opine on the borrower's own status incorporation, power, authorization, while the lender's Luxembourg counsel might opine specifically on the enforceability of the loan and security documents under Luxembourg law. It leverages expertise efficiently.
So the negotiation reflects risk allocation and professional duties. And that delicate transplant aspect might mean more discussion with international parties.
It can, yes. Parties used to different legal systems might have different expectations, so ensuring everyone's on the same page about what a Luxembourg opinion means and covers is key.
Okay, let's shift to the practicalities. Costs. What are we talking about for getting a legal opinion in Luxembourg finance deals?
Well, there are costs, definitely. It reflects the specialized expertise, the detailed work involved in due diligence, and the professional liability the law firm takes on.
Who usually pays?
Typically, the borrower or the issuer. It's considered a standard transaction expense.
And how are the costs structured? Hourly? Fixed fee?
Often hourly rates, especially for complex deals where the time involved is hard to predict up front. Fixed fees are less common for intricate financings, but might be possible for simpler ones. The cost depends on several things: the complexity of the deal and the company group, how many entities need opinions, how urgent it is, the breadth of the opinion requested, and if there are any really novel or tricky legal questions needing deep research.
So it reflects the work and the risk involved.
Exactly. It's payment for expertise, time, and taking on professional risk. Understanding what drives the cost helps with budgeting.
And timelines. How long does this process take? Deals often have tight deadlines.
Timing is absolutely critical, yes.
Yes.
Often, getting the final opinion is a condition precedent. The deal can't close, funds can't flow until it's delivered satisfactorily. Delays can be serious.
So who controls the timeline? Just the lawyers?
Not entirely. It depends heavily on how quickly the client provides all the necessary documents accurately and how responsive everyone is during the review and negotiation phases. It's a collaborative effort.
How can parties manage it effectively?
Early engagement is key. Talk to counsel early. Define the scope clearly from the start. And be proactive in getting them the documents they need.
And typical lead times? Days? Weeks?
It varies hugely. A simple opinion might take days. A complex, multi-party deal with tricky issues and lots of negotiation could take weeks, potentially longer. It's really interactive. Needs good management and cooperation to avoid being the bottleneck that holds up closing.
Now, the legal and regulatory world never stands still, especially in finance. What recent changes are affecting these legal opinions in Luxembourg?
There have been quite a few significant ones. A major one is DORA, the Digital Operational Resilience Act.
Ah, yes, DORA. Heard a lot about that.
It came into full force early 2025. It's EU-wide, aiming to boost cyber resilience for financial firms. And in response, the CSSF issued a batch of important circulars around April 2025.
What do they cover?
Various things. Enhanced ICT risk assessment for payment service providers, aligning with EBA guidelines. Updates to existing ICT risk rules, especially for firms not fully under DORA's scope. There are also specific rules for DORA firms about managing their ICT third-party providers, reporting requirements, keeping registers of contracts.
And outsourcing.
Yes, big focus there. Especially a strong reminder about professional secrecy obligations under Luxembourg law when using third-party providers, particularly concerning data access. The CSSF updated its general outsourcing rules, too, with nuances for DORA versus non-DORA entities.
So how does DORA impact the legal opinions themselves?
Likely means more due diligence around DORA compliance. We might see more detailed representations and warranties in the loan documents about it. Potentially new qualifications or carve-outs in opinions, especially around data access by third parties and the limits of what counsel can assess ongoing.
Beyond DORA, anything else?
Well, core laws get updated. Consolidated versions of the company's law and the financial collateral law were published relatively recently. Lawyers need to check if any changes affect standard opinions on capacity or security.
Right. Need the latest versions.
And the CSSF's expectations evolve. They've mentioned in FAQs they might request opinions for securitizations. EU-level developments from ESMA or EBA also filter down and influence practice here. Any significant new court cases, especially interpreting key laws, would also be relevant.
So it's a constantly moving picture.
It really is. Keeping up is crucial.
Looking ahead then, what trends do you see shaping the future of legal opinions in Luxembourg? How might they evolve?
Well, ESG, environmental, social, governance is one area. We probably won't see standard positive opinions on ESG compliance soon, but the scrutiny is increasing, meaning more ESG-related due diligence by lawyers, maybe more specific ESG clauses in the loan documents, perhaps more specific qualifications or assumptions and opinions relating to ESG risks or disclosures. Sanctions compliance, AML/CTF, those will remain critical due diligence areas for sure. Cybersecurity and data protection, even beyond DORA, are likely to grow in importance.
So maybe not new opinion clauses, but more focus in the background checks.
Often, yes. More pressure for comfort in new risk areas might lead to deeper diligence, more detailed client certificates, specific caveats in the opinion, and more demand for specialized advice rather than brand new standard opinion clauses.
What about standardization?
Efforts continue there. Industry bodies, legal associations like ALJB, they contribute to developing market practice and understanding. Harmonization is an ongoing process.
And technology, AI.
Technology will play a role. Legal tech might help with parts of due diligence, maybe preliminary drafting, but the core legal analysis, the professional judgment, that remains human and paramount. ESMA is already looking at AI in investing, so tech's influence will grow in law too.
This has been incredibly informative. A really deep dive into what can seem like a complex topic. It's clear these opinions are much more than just paperwork.
They really are. Indispensable, I'd say, for Luxembourg's finance and banking world. They provide that essential legal assurance, smoothing the path for countless complex deals in this international center.
So understanding them is key.
Absolutely. Understanding the civil law context, that delicate transplant idea, the vital role of thorough due diligence, the precision needed in the clauses, the negotiation involved, and keeping up with the evolving rules like DORA and its interplay with things like professional secrecy. It's all crucial.
And the bottom line.
At the end of the day, every deal is unique. There's just no substitute for tailored, expert advice from experienced Luxembourg counsel. They're the ones who can navigate the specific facts, the complexities, the nuances of local law, especially in those cross-border deals that are so common here. Local expertise is vital.
Well put. Thank you so much for sharing your insights today. Really valuable.
My pleasure. Glad to discuss it.
Hit that subscribe button and give us a like if you found this deep dive helpful. This has been the Luxembourg Funcast for you today.